welcome back to our channel Low Point, and this is Anisha Babu. In the previous two sessions, we have seen the rights of a consumer and where and how to file a consumer complaint. Well, we all know that things are better understood if we connect law with our day-to-day affairs. So in today's session, we are going to see some important landmark judgment in the field of Consumer Protection Act. So we have a Supreme Court of India advocate on record, Ms. Praseena Elizabeth Joseph, to brief us on the same. So let's watch.
Hi friends, in 1992, a 79-year-old Stella bought a cup of takeout coffee at McDonald's drive-thru and it spilled on her lap. She sued McDonald's and a jury awarded $3 million as compensation. Later, the parties compromised for a lesser amount. This happened in US. Coming to Indian scenario, purchase of goods and availing of services have become an inevitable part of our daily lives. Such purchase or consumption is essentially based on trust, failing which it can cause monetary loss, mental agony, physical harm to consumers. Through their decisions, District Commission, State Commission, National Commission and Honorable Supreme Court of India ensure to protect the consumers from defective goods, deficient services or unfair trade practices. Now, I'm going to talk about consumer case against corporate bodies. One striking example is where Rajesh Rajan purchased a bottle of Pepsi from a local store in Ahmedabad in the year 2008, but happened to find a gutka pouch inside the bottle. He immediately dashed off a legal notice to the company, accusing it of deficiency in service that could cause health hazards for consumers. The State Commission directed the company to pay Rs 22,000 as compensation to Rajesh. Similarly, Ms. Anupama lodged a consumer complaint wherein she alleged that while consuming Cadbury Dairy Milk roasted diamond chocolates purchased from a local shop in Guntur, Andhra Pradesh in July 2016, she found worms inside the chocolates. On her consumer complaint, Mondelez India Foods Private Limited, the parent company of Cadbury India, was fined Rs 55,000 by the Consumer Forum of Guntur. Next, we have the case of Ghaziabad Development Authority versus Dalbir Singh, decided in 2004. Balbir Singh had paid the full price of the plot or allotment as per the terms and conditions of the allotment letter. Yet, he was not given possession of the plot. So he filed a consumer case wherein the State Commission ruled that there is deficiency of service and directed refund of full amount paid for the plot with 18% interest from the date of deposit. In appeal, the National Commission upheld the State Commission's order and the same was confirmed by the Honorable Supreme Court of India. Another interesting case is Om Prakash versus Reliance General Insurance, decided in the year 2017. In this case, Om Prakash insured his truck with Reliance General Insurance. His truck was stolen on 23rd March 2010. The very next day, he filed a complaint with the police. Rajasthan police asked him to stay with them in order to help them trace the truck, because of which he could return to his village only on 30th March 2010. That is, after a week, his vehicle was stolen. And on the very next day, on 31st of March 2010, he filed claim petition with the Reliance General Insurance Company. However, company rejected his insurance claim on the ground of delayed intimation about the theft of the vehicle. Om Prakash filed consumer complaint before the District Commission, wherein District Commission dismissed his complaint. In appeal, both State Commission as well as National Commission dismissed his complaint. Not to give up so easily, Mr. Om Prakash filed appeal before the Honorable Supreme Court of India. And his persistent effort paid off. Honorable Supreme Court decided in his favour. Honorable Supreme Court observed that an insurance company can reject a claim if it is delayed intimation. But if the reason of delay is satisfactorily explained, such a claim cannot be rejected on the ground of delay. As such, Honorable Supreme Court directed the insurance company to pay a sum of Rs 8,35,000 to Om Prakash along with interest at the rate of 8% per annum from the date of filing of the complaint, and also Rs 50,000 as compensation. Please note that it is not just the corporate bodies which offer products and services which come under the purview of Consumer Protection Act. Even the medical profession comes under it. When Indian Medical Association approached the Honorable Supreme Court with the question as to whether service rendered to a patient by a medical practitioner by way of consultation, diagnosis, treatment, both medical and surgical, whether it will come under the purview of Consumer Protection Act or not, wherein the Honorable Supreme Court held that the services rendered by a medical practitioner fall under the purview of Consumer Protection Act. Now that we know the medical practitioners come under the Consumer Protection Act, our next case illustrates the same. Poonam Verma vs. Ashwin Patel, decided in 1996. Poonam Verma's husband Pramod Verma approached Dr. Ashwin Patel for his viral fever. Ashwin Patel was trained in homeopathy for 4 years and started his private practice. The certificate of registration issued to homeopathy practitioners states that it entitles them to practice in homeopathy only. Then also, he administered allopathic drugs for viral fever and typhoid fever without confirming the diagnosis by blood test or urine examination. And Pramod Verma passed away within 8 days of his treatment. Poonam Verma filed consumer complaint against Ashwin Patel for his medical negligence. The National Commission ruled in her favor, observing that doctor was negligent in administering strong antibiotics to Pramod Verma, initially for the treatment of viral fever and subsequently for typhoid fever, and awarded compensation of Rs 3 lakhs and Rs 30,000 as cost of litigation. Here we have seen a case of active medical negligence. Our next case is where National Commission decided in favor of the doctor. The case is Dr. M. Kocha vs. Ispita Seal, decided in December 2017. Ispita Seal approached Dr. Kocha for IVF fertilization procedure for conception of a child, but she did not conceive in spite of the procedure. Ispita approached State Commission complaining deficiency of service of doctor. State Commission ruled in her favor and directed compensation to be paid to her. However, in appeal, National Commission held that no success in IVF procedure is not a medical negligence and it cannot be treated as deficiency in service. Now that we have seen medical negligence comes under Consumer Protection Act, it would be interesting to know whether educational institutions also comes under Consumer Protection Act or not. In Maharishi Dayanand University versus Surjit Kaur, as well as in P.T. Koshi versus Alien Charitable Trust, decided in 2010 and in 2012 respectively, wherein Honorable Supreme Court held that student is not a consumer and educational institutions are not service providers. So, complaint against educational institutions does not come under Consumer Protection Act. Now, let us look at pending corporate cases, and these could be of interest to you. One such case is Nikhil Jain used the product Fair and Handsome Cream of Miss Imami Limited, advertised and claimed to be world's #1 fairness cream for men. Despite that, it failed to show any of the desired results. So, Nikhil Jain filed a consumer complaint alleging that Mrs. Imami Limited had adopted unfair trade practice by promoting its product as world's #1 fairness cream for men. Our next case is a consumer case filed by the Department of Consumer Affairs in the National Commission against Nestle India Limited on the ground of unfair trade practice, sale of defective goods, and sale of Maggi oats noodles to the public without product approval. I hope all of you gained insight on your consumer rights and will exercise your rights wisely.
Thank you for watching. So for our next frequently asked question sessions, please send us your questions below in the comment box. Catch you later.